Friends, my name is Nizamuddin Ahmed Siddiqui and I am an assistant professor of law at West Bengal National University of Juridical Sciences, Kolkata. I will be taking this unit on judicial expansion of rights on behalf of the content writer Dr. K. Sita Manikayam, assistant professor Dr. B.R. Ambedkar Law College, Andhra University. This unit aims to fulfill certain learning objectives, which include an understanding about judicial activism as it has developed in India, understanding of the role of judiciary in the expansion of fundamental rights that are provided by the Constitution. With these two objectives, let us now understand in brief what this unit deals with. Judiciary in every country has an obligation and a constitutional role to protect human rights of citizens. As per the mandate of the Constitution of India, this function is assigned to the superior judiciary, which includes the Supreme Court of India and the High Courts of various states. The preamble to the Constitution of India encapsulates the objectives of the constitution makers to build a new socio-economic order where there will be social, economic and political justice for everyone, and equality of status and opportunity for all. This basic objective of the Constitution mandates every organ of the state, the executive, the legislature and the judiciary working harmoniously to strive to realize the objectives concretized in the fundamental rights and directive principles of state policy. Judicial activism has greatly contributed to the expansion, protection and enforcement of fundamental rights and have further impacted on the justiciability of the directive principles of state policy in India. A study of the notable cases of the Supreme Court speak of the fact that the Indian judiciary has adopted strong sentiments in favor of public interest through public interest litigations, and the functioning of judiciary reveals that it has exercised its powers in the most creative manner by devising new strategies to ensure the protection of human rights to the people. The Supreme Court of India has used this strategy of public interest litigations as an aid to enforce the rights of prisoners, workers, pensioners, victims of environmental pollution and others. The public interest litigation plays a key role in ensuring the principle of the rule of law by making the administration accountable to the people. The Supreme Court of India in Narmada Bachao Andolan versus Union of India held that public interest litigation was an invention essentially to safeguard and protect the human rights of those people who were unable to protect themselves. The Supreme Court widened its scope by liberally interpreting the term other authorities given under Article 12 defining the state. The Supreme Court stated that the expression other authorities in Article 12 is wide enough to include all authorities created by the Constitution or statute or on whom powers are conferred by law. It is not necessary that statutory authority should be engaged in performing sovereign functions. Since then, there has been a growing widening of the meaning of other authorities. Now, several categories of the state instrumentalities such as public corporations, companies, societies, etc. have come to be included within the ambit of other authorities. The fundamental rights are binding on them and they are amenable to the writ jurisdiction of the court under Article 32 and 226 of the Constitution. Friends, we will now consider the judicial pronouncements on the interpretation of fundamental rights and directive principles in this unit one by one. Let us begin by considering the way right to life and personal liberty provided under Article 21 of the Constitution has been expanded by the honorable courts. The judicial interpretation with respect to the terms life, personal liberty and procedure established by law changed from case to case and time to time. The scope of the right to personal liberty received two-dimensional judicial approach in the Gopalan case, which is the very first case on personal liberty in the Supreme Court of India, immediately coming after the commencement of the Indian Constitution. The majority opinion in the case was that the right to personal liberty was not so wide as to include within it the freedom of movement throughout the territory of India. The judges were of the view that the concept of right to move freely throughout the territory of India referred to in Article 19(1)(d) of the Constitution was entirely different from the concept of right to personal liberty referred to in Article 21 and should not therefore be read as controlled by the provisions of Article 21. The majority judges were of the opinion that if the concept of personal liberty was interpreted to include the freedom of movement throughout the territory of India, then Article 19(1)(d) would become redundant, and they kept both the freedoms in separate compartments. It thus appears that the majority gave a very narrow and restricted view of the expression personal liberty. Post Gopalan, the scenario in respect of scope of Article 21 has been expanded or modified gradually through different decisions of the apex court. And it has been held that interference with the freedom of a person at home or restriction imposed on a person while in jail would require authority of law. Whether the reasonableness of a penal law can be examined with reference to Article 19 was the point in issue after Gopalan's case in the case of Maneka Gandhi versus Union of India. The apex court opened up a new dimension and laid down that the procedure cannot be arbitrary, unfair or unreasonable one. Article 21 imposed a restriction upon the state where it described a procedure for depriving a person of his life or personal liberty. Let us now look at the issue of judiciary and gender justice. In the case of Vishakha and others versus State of Rajasthan, the Supreme Court said that gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. The common minimum requirement of this right has received global acceptance. In the absence of domestic law occupying the field, to formulate effective measures to check the evil of sexual harassment of working women. At workplaces, the contents of international conventions and norms are significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity in Articles 14, 19, 1G, 15 and 21 of the Constitution, and the safeguards against sexual harassment implicit therein, and of course for the formulation of guidelines to achieve this purpose. In the absence of an enacted law to provide for the effective enforcement of the basic human right of gender equality and guarantee against sexual harassment and abuse, more particularly, guidelines and norms were laid down for strict observance at all workplaces or other institutions till the point the legislation is enacted for the purpose. This was done in exercise of the power available to the court under Article 32 for the enforcement of the fundamental rights. And it is further emphasized that this would be treated as the law declared by the Supreme Court under Article 141 of the Constitution. Judiciary and prisoners' right is one another issue. Friends, it is beyond doubt that in the recent past, the Indian judiciary, particularly the Supreme Court, has been very vigilant against encroachments upon the human rights of prisoners. The courts have recently viewed third-degree methods and custodial deaths in police custody as a serious violation of human rights and constitutional provision of right to life and liberty. The Supreme Court of India and the High Courts have developed human rights jurisprudence for prisoners' rights by interpreting Articles 14, 19, 21, 22, 32, 37 and 39A of the Constitution. Reiterating the view taken in Motiram and others versus State of Madhya Pradesh, the Supreme Court in Hussain Ara Khatun and others versus Home Secretary State of Bihar expressed anguish at the travesty of justice because under trial prisoners spending extended time in the custody due to unrealistically excessive conditions of bail which were imposed by the magistracy or the police, and it issued requisite corrective guidelines holding that the procedure established by law for depriving a person of life or personal liberty also should be reasonable, fair and just. Strongly denouncing handcuffing of a prisoner as a matter of routine, the Supreme Court said that to manacle a man is more than to mortify him. It is to dehumanize him and therefore to violate his personhood. Further, in M.H. Hoskote versus State of Maharashtra, the Supreme Court laid down that the right to free legal aid at the cost of state to an accused who could not afford legal services for the reasons of poverty, indigence or incommunicado situation was part of fair, just and reasonable procedures implicit in Article 21. A three-judge bench of Supreme Court reading Articles 21 and 39A along with Article 142 and Section 304 of Criminal Procedure Code clearly provided that the government is under duty to provide legal services to the accused persons. In Muhammad Ajmal Muhammad Amir Kasab alias Abu Mujahid versus State of Maharashtra, the Supreme Court held that no hesitation in holding that the right to access to legal aid, to consult and to be defended by a legal practitioner arises when a person arrested in connection with a cognizable offence is first produced before a magistrate. The Supreme Court accordingly held that it is the duty and obligation of the magistrate before whom a person accused of committing a cognizable offence is first produced, to make him fully aware that it is his right to consult and be defended by a legal practitioner. And in case he has no means to engage a lawyer of his choice, that one would be provided to him from legal aid at the expense of the state. The right flows from Articles 21 and 22(1) of the Constitution and needs to be strictly enforced. The Supreme Court directed all the magistrates in the country to faithfully discharge the aforesaid duty and obligation, and further make it clear that any failure to fully discharge the duty would amount to dereliction in duty and would make the concerned magistrate liable to departmental proceedings. Friends, the judiciary has also discussed the issue of narco-analysis taken upon a prisoner under the ambit of fundamental rights. In Ramchandra Ram Reddy versus State of Maharashtra, the Bombay High Court. In Srimati Selvi versus Karnataka, the Karnataka High Court. And in Rojo George versus Deputy Superintendent of Police, the Kerala High Court held that narco-analysis test does not amount to deprivation of personal liberty or intrusion into privacy. But the Indian Supreme Court addressed the issue in Srimati Selvi versus State of Karnataka by observing that subjecting a person to the imputed techniques in an involuntary manner violates the prescribed boundaries of privacy. Forcible interference with a person's mental processes is not provided for under any statute, and it most certainly comes into conflict. So far, the judicial understanding of privacy in our country has mostly stressed on the protection of the body and physical spaces from intrusive actions by the state. While the scheme of criminal procedure as well as evidence law mandates interference with physical privacy through statutory provisions that enable arrest, detention, search and seizure among others. The same cannot be the basis for compelling a person to impart personal knowledge about a relevant fact. The theory of interrelationship of rights mandates that the rights against self-incrimination should also be read as a component of personal liberty under Article 21. In TV Vatheeswaram versus State of Tamil Nadu, the Supreme Court held that delay in execution of death sentence exceeding 2 years would be sufficient ground to invoke protection under Article 21, and the death sentence would be commuted to life imprisonment. The cause of the delay is immaterial. The accused himself may be the cause of the delay in such situations. In Sher Singh versus State of Punjab, the Supreme Court said that the prolonged wait for execution of a sentence of death is an unjust, unfair and unreasonable procedure, and the only way to undo that is through Article 21. But the court held that this cannot be taken as the rule of law and has to be applied to each case, and each case should be decided upon its own facts. The Rajasthan High Court, by an order, directed the execution of the death sentence of an accused by hanging at the stadium ground of Jaipur. It was also directed that the execution should be done after giving widespread publicity through the media. On receipt of the above order, the Supreme Court in Attorney General of India versus Lashma Devi held that the direction for execution of the death sentence was unconstitutional and violative of Article 21. it was further made clear that death by public hanging would be a barbaric practice. Although the crime for which the accused was found guilty was barbaric, it would be a shame on the civilized society to reciprocate the same. The court said, a barbaric crime should not have to be visited with a barbaric penalty. Friends, let us now look under right to health in the Indian Constitution. In Permanent Katara versus Union of India, it has been held that it is the professional obligation of all doctors, whether government or private, to extend medical aid to the injured immediately to preserve life without waiting for legal formalities to be completed by the police under the Code of Criminal Procedure. Article 21 of the Constitution casts an obligation on the state to preserve life. It is the obligation of those who are in charge of the health of the community to preserve life so that the innocent may be protected and the guilty may be punished. Social laws do not contemplate death by negligence, which amounts to legal punishment. In Paschim Bang Khet Mazdoor Samiti versus State of West Bengal, following Permanent Katara, the Supreme Court held that the denial of medical aid by government hospitals to an injured person on the ground of non-availability of beds amounted to violation of right to life under Article 21 of the Constitution. The Supreme Court held that Article 21 imposes an obligation on the state to provide medical assistance to every injured person. Preservation of life is paramount importance. Failure on the part of the government hospitals to provide timely medical treatment to a person in need of such treatment results in violation of his right to life guaranteed under Article 21 of the Constitution. The court also directed that the state should pay Rs 25,000 to the petitioner as compensation. In another case, Paschim Banga Khet Mazdoor Samiti versus State of West Bengal, it has been reiterated time and again that there should be no impediment to providing emergency medical care. In Pravat Kumar Mukherjee versus Ruby General Hospital and others, it was held that a hospital is duty bound to accept accident victims and patients who are in critical condition, and that it cannot refuse treatment on the ground that the victim is not in a position to pay the fee or meet the expenses, or on the ground that there is no close relation of the victim available who can give consent for medical treatment. The court has laid stress on a very crucial point, that is, the state cannot plead lack of financial resources to carry out these directions meant to provide adequate medical services to the people. The state cannot avoid its constitutional obligation to provide adequate medical services to the people because of the financial constraints. But in the state of Punjab versus Ram Lubhaya Bagga, the Supreme Court has recognized that the provision of health facilities cannot be unlimited. The court held that it has to be to the extent finance permits. No country has unlimited resources to spend on any of its projects. In Confederation of Ex-Servicemen Association versus Union of India, right to get free and timely legal aid of facilities has been held to be a fundamental right of ex-servicemen. A policy decision in formulating contributory scheme for ex-servicemen and asking them to pay one-time contribution was held to be not violative of Article 21 and also not inconsistent with Part 4 of the Constitution. Playing active role in the matters involving environment, the judiciary in India has read the right to life enshrined in Article 21 as inclusive of right to clean environment. The court has time and again expressed concerns about the impact of pollution on our ecology in present and in the times to come, and the obligation of the state to anticipate and prevent the causes of environmental degradation. The state has to secure the health of the people, improve public health, and protect and improve the environment. The state has an obligation to improve public health and to improve the environment. In Vellore Citizens Welfare Forum versus Union of India, the court took cognizance of the environmental problems being faced by tanneries that were polluting the water. It is the obligation of the state to anticipate and prevent environmental degradation and to secure the health of the public. In Vellore Citizens Welfare Forum versus Union of India, the court took cognizance of the environmental problems being caused by tanneries that were polluting the water through its resources in rivers, canals, underground water, and agricultural land. The court issued several directions to deal with the problem. Similarly, in Milkman Colony Vikas Samiti versus State of Rajasthan, the Supreme Court held that the right to life means clear surrounding which lead to healthy body and mind. It includes right to freedom from stray cattle and animals in urban areas. In the celebrated case of M.C. Mehta versus Union of India, the court held that the blatant and large-scale misuse of residential premises for commercial use in Delhi violated the right to salubrious sand descent environment. Taking note of the problem, the court issued directives to the government on the same. In Murli S. Deora versus Union of India, the persons not indulging in smoking cannot be compelled to or subjected to passive smoking on account of the act of smokers was recognized by the court. Right to life under Article 21 is affected as a non-smoker may become a victim of someone smoking in a public space. This is what the court said. Let us discuss right to die. Article 21 confers on the person the right to have life and personal liberty. Friends, let us now discuss the right to die. Article 21 confers on a person the right to live a dignified life. Does it also confer a right not to live or a right to die if a person chooses to end his life? If so, what is the fate of Section 309 of Indian Penal Code, which punishes a person convicted of attempting to commit suicide? There has been difference of opinion on the justification of this provision to continue on the statute book. In P. Ratinam versus Union of India, a two-judge division bench of the Supreme Court took cognizance of the relationship and contradiction between Section 309 IPC and Article 21. The court supporting the decision of the High Court of Bombay in Maruti Sripati Dubal case held that the right to life embodies in Article 21 a right not to live a forced life to the detriment or disadvantage of the person. The court argued that the word life in Article 21 means right to live with human dignity, and the same does not merely connote continued drudgery. Thus, the court concluded that the right to life, of which Article 21 speaks of, can be said to bring in its trail the right not to live a forced life. The court further emphasized that attempt to commit suicide is in reality a cry for help and not for punishment. The Ratinam ruling came to be reviewed by a full bench of the court in Gyan Kaur versus State of Punjab. The question in the case before the court was whether the principal offence of attempting to commit suicide is void as being unconstitutional vis-a-vis Article 21, and if that is the case, how abatement thereof be punishable under Section 306. It was argued that the right to die, having been included in Article 21 and Section 309 having been declared unconstitutional, any person abetting the commission of suicide by another is merely assisting in the enforcement of his fundamental right under Article 21. The court overruled the decision of the division bench in the above stated case and put an end to the controversy and ruled that Article 21 is a provision guaranteeing protection of life and personal liberty, and by no stretch of imagination can extinction of life be read to be included in the protection of life. The court observed further that the right to life is a natural right embodied in Article 21, but suicide is an unnatural termination or extinction of life and therefore incompatible and inconsistent with the concept of right to life. In Gyan Kaur versus State of Punjab, the Supreme Court has distinguished between euthanasia and attempt to commit suicide. The court held that death due to termination of natural life is certain and imminent, and the process of natural death has commenced. These are not cases of extinguishing life, but only of accelerating conclusion of the process of natural death that has already commenced. The court further held that this may fall within the ambit of right to life with human dignity up to the end of natural life. This may include the right of a dying man to also die with dignity when his life is ebbing out. This cannot be equated with the right to die in a natural death, curtailing the natural span of life. Friends, right to education has also been recognized as a human right to be protected and preserved. Its importance has also been recognized by the framers of the Constitution under Article 44 of the Constitution. Friends, right to education has been recognized as a human right to be protected and preserved. Its importance has also been recognized by the framers of the Constitution under Article 41 of the Constitution. So as to convert a right to education into a fundamental right to education, the courts in India played a vital role. In Mohini Jain versus State of Karnataka and others, the observations of the court were as follows. The directive principles which are fundamental in the governance of the country cannot be isolated from the fundamental rights which are guaranteed under Part 3 of the Constitution. These principles must be read into the fundamental rights. Both of them are supplementary to each other. The state is under a constitutional mandate to create conditions in which the fundamental rights guaranteed to the individual under Part 3 could be enjoyed by all. Without making right to education under Article 41 of the Constitution a reality, the fundamental rights under Chapter 3 shall remain beyond the reach of large majority which is illiterate. Friends, right to life is the compendious expression for all those rights which the courts must enforce because they are basic to the dignified enjoyment of life. The court holds that every citizen has a right to education under the Constitution. The state is under an obligation to establish educational institutions to enable the citizens to enjoy the said right. The state may discharge its obligation through state-owned or state-recognized educational institutions. When the state government grants recognition to the private educational institutions, it creates an agency to fulfill its obligation under the Constitution. The students are given admission to the educational institution, whether owned by the state or recognized by the state, in recognition of their right to education under the Constitution. In Unni Krishnan, JP and others versus State of Andhra Pradesh, the court stated, in order to treat a right as a fundamental right, it is not necessary that it should be expressly stated as one in Part 3 of the Constitution. The provisions of Part 3 and 4 are supplementary and complementary to each other. Fundamental rights are but a means to achieve the goal indicated in Part 4 and must be constructed in the light of the directive principles. That right to education is implicit in the right to life is that the state cannot deprive the citizen of his right to education except in accordance with the procedure prescribed by law. Fundamental rights are but a means to achieve the goal indicated in Part 4 and must be constructed in the light of the directive principles. That right to education is implicit in the right to life is that the state cannot deprive the citizen of his right to education except in accordance with the procedure which is prescribed by law. The right to education, which is implicit in the right to life and personal liberty, guaranteed by Article 21, must be constructed in the light of the directive principles in Part 4 of the Constitution. The declarations of the right to education as a fundamental right has been further confirmed by the 11-judge constitutional bench of the Supreme Court in TMA Pai Foundation versus State of Karnataka. The notion that private unaided educational institutions are entitled to earn profits and not to profiteer has been affirmed by the Supreme Court in a recent case of unaided private schools of Delhi versus Director of Education. The court has allowed the management to adopt a rational fee structure and directed the government to frame a scheme relating to the grant of admission and fixing the fee and to check whether the commercialization of education is being done or not. Friends, in conclusion, we can say that judiciary has played a proactive role in all spheres, be it environment, police system, status of women, etc., leading towards their amelioration and ensuring that justice is delivered in its entirety. Judicial activism is not an aberration. It is an essential aspect of the dynamics of a constitutional court. It is a counter-majoritarian check on democracy. Judicial activism, however, does not mean governance by the judiciary. It also must function within the limits of the judicial process. With this, we come to an end of this presentation. Friends, I thank you all for listening with patience.